Dolly Mapp was a criminal to her eyeballs, involved in unlawful racketeering and illicit gambling in Cleveland, Ohio, and later jailed for heroin offences. In 1957, police attended her home looking for another criminal named Virgil Ogletree. They didn't have a warrant, so she sent them away. They returned a few hours later and burst in, cuffing her and giving her a document that she didn't have time to read. It was later confiscated. It seems clear that they never had a warrant. Police found Ogletree on the premises and also found some unlawful pornographic magazines. Dolly was charged with possessing those. At trial, her counsel argued that the magazines could not be put into evidence because they had been obtained unlawfully, and so they had. Dolly might have been a criminal, but she still had the right not to have her home invaded by police. As the Supreme Court majority later said, nothing could be more certain than that when a coerced confession is involved, the relevant rules of evidence are overridden without regard to the incidence of such conduct by the police, slight or frequent. Why should not the same rule apply to what is tantamount to coerced testimony by way of unconstitutional seizure of goods, papers, effects, documents, etc.? The difficulty was that while the Fourth Amendment of the US Constitution protected people from unreasonable searches and seizures, many states had no similar laws. The question which followed was whether the Fourth Amendment applied to the state government in Ohio. The argument was that the 14th Amendment, which applies to states and protects due process, would cover the Fourth Amendment. In other words, a person couldn't be said to be getting due process if they were convicted on the basis of illegally obtained evidence. The majority judges said, there is no war between the Constitution and common sense. Presently, a federal prosecutor may make no use of evidence illegally seized, but a state's attorney across the street may, although he supposedly is operating under the enforceable provisions of the same amendment. Thus, the state, by admitting evidence unlawfully seized, serves to encourage disobedience to the federal constitution which it is bound to uphold. From this case, then, we learn that the Fourth Amendment protection against unreasonable search and seizure means that evidence unlawfully obtained during such a search or seizure is not admissible in a criminal trial.